friends. And thank you so much for coming to spend part of your day with me today. It is Tuesday, April 23rd, 2024, and it is 5:15 p.m. on the East Coast. It's a beautiful day today. I wonder if you guys up there in the Norfolk County area had a beautiful day today as well. It was like 60 degrees and sunny, and it finally feels like spring is coming. It's about time. And the NHL playoffs, the Stanley Cup playoffs are happening tonight. The Rangers play at 7, so I wanted to get in here at 5:15, do this with you guys and talk about what's going on with the Karen Reed jury selection. There was no court today, but they will go back tomorrow, but then there will be no court on Thursday, Friday. So, I don't know what's up with that, but now they're looking for 20 jurors instead of 16. Originally, they had set on a number of 16. 12 to sit on the jury with 4 alternates. But now they are going to try and get 20 jurors, and they're up to 19. But there seems to be something happening with hardships and people who are going to apparently come in with some reasons why they can't serve or are not able to serve anymore. And there's some stuff going on there that makes me go, So let's see what you guys are saying. What you guys are saying about this. Ted Daniel has been the one who's been live tweeting from the courtroom. And so he's in there and he's boots on the ground. But again, nothing happened today. And they're trying to cancel him for wearing a pink shirt the other day. So there's that going on. It's insanity. This is going to be a trial unlike anything certainly that Massachusetts has ever seen since I think it was 1920 when Sacco and Vanzetti were tried in the exact same courthouse, by the way, the exact same courthouse. So we're going to look at, I don't know, Ruby, it's like the waiting is the hardest part, as Tom Petty said. The waiting is the hardest part. I cannot even imagine what the families are going through. And now we're looking at maybe a start date of next Monday, maybe. I don't know, Ruby. I don't know if it's ever going to start. It feels like the waiting is the hardest part for sure. And do we have any Criminal Minds fans in the chat today? I know so many of you are such true crime fans. And Criminal Minds is a big favorite of mine. And when I was talking about that horrific case out of the Oklahoma Panhandle, it kept reminding me of I forget which season it was, finale with the hog farm, and I cannot unsee that episode. If you know, you know. Yeah, I love Criminal Minds. So remember how with every Criminal Minds episode, they would start with like a quote? Here's your quote for the day. Socrates once said, "When the debate is lost, slander becomes the tool of the losers." If you know, you know. That, my friends. And they would say every episode they would open with something like, Teddy Roosevelt once said, or John Adams once said, or John Quincy Adams, as the judge in this case likes to quote. But that is what Socrates once said. And I think that is a very excellent quote to start off this stream, because I've never seen anything like it. Never seen anything like it in the entirety of my career. I didn't see anything like it during the litigation of the cases against the Catholic Church, which was a very divisive case. And it's too bad. It's too bad, but I can't imagine what the parties are going through. I mean, this is insane. This is insanity. So thank you, Will, for your show last night, because we needed to laugh really, really badly. And it came into my feed at something like 11 o'clock. And I don't know how you did it, but you were on for 7 hours or something yesterday. And I started watching you breaking down that one video in the beginning. And I mean, it's comedy gold, man. It is comedy gold. It is exactly what I needed. And I really laughed for like 2 full hours. So thank you to the Glarer. If you're not subscribed, go on over there and subscribe, because that is some comedy gold, my friend. Wow. So what we are going to do today is we're going to look at the Commonwealth's response to the motion that the defense made to rearrange the seating in the courtroom, because something like 6 of the jurors seated in the jury box, the way the jury box is configured in this courtroom, will only be able to see either the back of the witness's head who is testifying or the side profile of the witness who is testifying. And I've never seen anything like that either. But the Commonwealth seems to think that it's been done that way in this courthouse for 100 years, so it should still be done that way. No big whoop. Doesn't matter if you can't see the witness's face. You can still, detect their demeanor by their tone of voice and their body language. So I 100% disagree with that. I think that seeing a witness's face is imperative to assess a witness's credibility. You can let me know what you think. Anybody who's familiar with this courthouse in Dedham can let me know what you know about Courtroom 25, because that's the other option that the Commonwealth is suggesting to move this trial, which is, as you know, a media firestorm and also an observer firestorm, because people are waiting in line to get into the courtroom, and a lot of people don't get in, right? There's limited seating, so they want to move it to a smaller courtroom. That's their other suggestion. I don't know that that would be a great idea. Suzanne, Courtroom 25 is very small. I knew somebody over there would know. Very small. But, I mean, it's... Wait, hold on a second. I saw something, Arson. Hold on. I agree, the glare is great, but that super chat thing is so annoying to me. Okay, that is... I sometimes skip through it, I gotta be honest, but I think last night when I needed some real comedy gold, like, that was really funny. I think I got a super chat. Like, person dancing. It was what I needed last night. So yeah, Ruby says the other courtroom is tiny. Scott, hey Scott McGinnis, I saw you. I was in a chat the other day when you were live in front of the courthouse, and it's nice to put faces to the names. So I think whoever was out, I think it was Brian who was out there, and I was like, Brian, tell people to introduce themselves, because I really like to meet you, and I'm not there, so I'm here. And then we're going to look at the Commonwealth's opposition to the fact that the defense wants to call the district attorney, Michael Morrissey, to testify, and the witness advocate to testify, and they would like an offer of proof on that. So I think because we're going to go through that, we're going to have to go back and watch the hostage video again, because I have some ideas of why they want to call him to testify. And in many ways, I think that he should be. He should be testifying in this case, because it is my opinion that he inserted himself into this case as a witness of certain facts and where certain people were on the night in question, and who was in the house and who wasn't in the house. And he inserted himself into this case. So I believe that the defense should be allowed to question him as to how he knows these things and what the source of his knowledge is. So this is interesting, to say the least. A lot of twists and turns happening here. Let's take a look at some local coverage, as we like to do, from CBS Boston about what is happening. This is a recap of day 4 of jury selection. I believe that this was published, it says 17 hours ago. So let us take a look at this first. And as always, just let me know that you can hear it, because sometimes the volume on these videos is just not up to snuff, and I don't have one of those fancy, sound modulators, so can't really do a whole lot about that. And here we go.
E2117, Karen Reed, Commonwealth, identify themselves for the record.
Morning, Honor. Well, have you ever heard of 19 jurors in a court case? Well, 19 people have been selected as jurors for the murder trial of Karen Reed, but it's still not enough. And it's all because of how this case has divided the community. WBZ's Tammy Mutasa explains this unusual step.
This jury selection process has been dragging on, but hopefully things will wrap up on Wednesday. But experts say this case is going to be about credibility, so finding impartial jurors is very important, no matter how long it takes. 1 week from today, Karen Reed could finally hear the opening statements in her trial for the murder of her boyfriend, Boston police officer John O'Keefe. Reed's defense team certainly ready to get things going.
What is up with the lighting right there? I don't know. They're making AJ look orange, but it's odd.
Of course, we've been ready.
But only when jury selection is finally finalized. So far, 19 jurors have been seated. Attorneys say the judge wants to see 20 potential jurors so that up to 4 can be dismissed if any problems come up.
I think it's fairly unusual to have 20 jurors and with the idea of winnowing it down to 16. But everything about this case has been pretty unusual.
On Monday, 91 potential jurors were interviewed. About 78 had heard or discussed the case.
Okay, so again, 78 people have heard of the case. That doesn't mean that they're automatically disqualified. What that just means is that they need to be questioned further about whether or not they have formed any opinions about the case. Just because you've heard about the case does not automatically disqualify you. But you're going to see that a lot of the jurors do raise their hand when they say, have you formed opinions? Do you have, thoughts about innocence or guilt? Do you have a bias towards either side? Do you know any of the people involved in this case or any of the witnesses who are going to testify in this case? And there are many people in this county who do have or will admit to having some preconceived notions about how this case should go. And those people, should be dismissed. So
32 already had an opinion on it, and 13 felt biased toward one side or the other. Law experts say while the selection process has stretched for 2 weeks, it's for good reason. In the meantime, both sides are looking to settle some issues before trial, like will Norfolk District Attorney Michael Morrissey be required to testify?
Innuendo is not evidence.
The defense has him on their witness list, claiming he will testify about a conflict Canton police had with the investigation. Reed supporters have blamed Morrissey for missteps in the investigation.
okay, tell me. Oh, wait, let me go back to that shot. Tell me if you see yourself outside the courthouse. I think that's Scott McGinnis there. Hang on a second.
This list, claiming he will testify about a conflict Canton police had with the investigation. Reed supporters have blamed Morrissey for missteps in the investigation.
Anybody? Is that Scott McGinnis in the green sweatshirt? And you can see how far the peaceful protesters, if you will, are from the courthouse. The gold dome in the background here is the courthouse, and you can see how far away they are now required to be with this 200-foot buffer zone. Okay, so that's Scott McGinnis, who's always here, very sportive in chat with the green sweatshirt on. Who's got the American flag here with the blue sweatshirt? I need to come back to the chat. If I swipe myself out, don't worry. I always come back. I always come back. Let's see if anybody else can tell me who. Yeah, Robin, a smaller courtroom means less people can get in to watch. Yep. I don't know. Oh, here's Scott McGinnis. This is simply understood. Nancy Bev is in on the corruption, must protect the DA Marcy. I have so many questions, and I have had so many questions since I started covering this case with you in January, and I've done well over 50 hours of analysis on this case, and I still have so many questions. Kevin C is in the blue sweatshirt. All right, Kevin. Thank you. All right.
But prosecutors say other witnesses will testify that Canton police removed themselves from the case because of a family relationship with witnesses. So at the end of trial, 12 jurors will actually be randomly selected out of that group of 20 people, and they will decide Reed's fate. In Dedham, Tammy Mutasa, WBZ News.
The courtroom today as jury selection.
Okay, I pulled a second clip because we need to hear from more than one source. This is from NBC 10 WJAR. Is that a Boston channel? I think it is. We are outraged. Ms. Smith says it was peaceful. Insert today's buffoon. Hopefully they can ignore him so he doesn't do too much damage. I don't know what you're talking about, but this morning was crazy, Jackie said. Thanks, Tom and Glare. Yes, Melissa. Has anyone else tried explaining this case to a friend and they think you're making it up? They think you're making it up. They think you're making it up. And also it's like, wait a minute, are you telling me about a movie that you saw? Or are you telling me about something that is really happening right now? And since we have started covering this case together, I'm going to say, originally when police officer John O'Keefe was murdered on January 29th of 2022, this was a local Boston story. And the local Boston channels, and we looked at the coverage the other day, I've got receipts, I've got the clips. The local Boston channels immediately started reporting that Karen Reed, the girlfriend of Officer John O'Keefe, hit him with her car and left him to die in the snow on the lawn of Boston police officer Brian Albert in Canton, Massachusetts. And investigators have said that there is Ring video footage and Ms. Reed's car was impounded. That is how it was first reported. I think a lot of people who heard those stories, including myself, thought, oh, wow, that's terrible. That's tragic. There's video of it, so yeah, guilty, I guess. But it turns out that that's not true. There is no video of the actual incident. There is no Ring doorbell footage of Karen striking John with her car. And from what we have uncovered by reviewing court documents, police reports, investigative reports, witness statements drafted by state troopers in this case, evidence logs, and actual, I can't say it enough, actual court documents. And by analyzing the actual court hearings that were televised, there is so much more to this case than people originally were told. And while it was originally a Boston story, it then became an East Coast story, let's say. And then as more people started covering it, and as Aidan Carney started reporting on it more and more, it started receiving more attention. And by the time I got involved in this case, admittedly in January of 2024, because my audience is international and there are, I don't know how many other YouTubers are covering. Will, I'm sure you have an international audience. Maybe Brian might as well, LTL True Crime. Sean McDonough, who now has a YouTube channel. It's become an international story. And there are YouTubers internationally who are covering this. And nobody can believe it. And it just keeps getting crazier and crazier. And then there's this 200-foot buffer zone issue and free speech being stifled. And you don't have to agree with me. These are my opinions. And I'm going to share them with you because why else would you want to watch a legal analyst? If you'd like to watch someone who's neutral and who wants to, spit out stuff or watch a photo montage that is narrated by a robotic AI voice, then you're free to do that. But this is my channel and I'm going to tell you what I think based on my probably up to 60 hours of analysis on this case live, in addition to all the work that I've done behind the scenes reading the documents. So this is now going to be one of the biggest trials we have seen in true crime, at least the past few years that I can think of. I mean, Johnny Depp and Amber Heard was a circus, but that was a civil case. I don't know that we've seen a case this divisive since OJ, and that was 1994. I think the verdict came down in 1995. And I remember that because it was right after Jerry Garcia died, which was the same year. So let's take a look at this other local coverage. And I think this was just put out 2 hours ago. I don't know if it aired yesterday, though. It may have.
Continued today in the murder trial of Karen Reed. She's the Bristol County woman accused in connection with her boyfriend's death in what's become a high-profile murder case.
Yeah, no testimony yet in what's become the real talker in the tabloids. NBC 10's Katie Benoit is covering for us. She's live at Norfolk County Superior Court in Dedham tonight. Katie?
Gina and Patrice, so far 19 jurors have been chosen. That's more than needed, but the defense says they're hoping to get to 20.
Of course. We've been ready.
Karen Reed and her supporters outside Norfolk Superior Court after
I want to point out that yellow police tape. And I want to point out to you that they couldn't find that yellow tape when it came time to secure the crime scene surrounding Officer John O'Keefe's dead body. But they can find it to keep people, general public, from ascending the courthouse steps. Okay? The irony.
day 4 of jury selection. It's a case that's captured national attention.
High-profile cases are very, very difficult to find the jury. It's one of the toughest things you have to do in a high-profile case. Some jurors run for the hills. They don't want to be involved. Other jurors are looking to be on.
Prosecutors allege Reed, who's from Mansfield, struck and killed her boyfriend, John O'Keefe, a Boston police officer, in January of 2022 at a Canton home. The defense says Reed is being framed. They're planning on arguing third-party culprit defense. So far, the court clerk says 19 people have been seated. Only 16 are needed for opening statements. But there could be potential issues with jurors. The defense says the hope is to seat 20, eventually excusing 4. Jurors have been asked to answer 29 questions, which our NBC 10 legal expert says is common.
Jurors are far more apt to be honest.
According to court documents, the defense claims not all members of the jury would be able to see witnesses' face once the trial is underway. The state is proposing moving the case to another courtroom in the building.
So whatever accommodations the jury needs, the jury should have. You do not want a case going up on appeal because a juror later on says, I couldn't see this witness or I didn't understand this witness.
100%. 100%. How the Commonwealth can even oppose that motion with a straight face is beyond me. It's beyond me. But we're going to look at that opposition.
Jury selection is expected to continue here on Wednesday. The clerk says there will be about 100 people here, similar to today. Live in Dedham, Katie Benoit, NBC 10 News.
Okay, so they're coming back tomorrow with 100 more jurors, and hopefully they're going to be able to find one more. So apparently they have 19. They're looking for 20, but there are a handful of jurors who have excuses or want to speak to the judge, I guess, to try and not serve or have reasons why they can't serve. Thank you, Maureen Francis, so much for the Cash App, always coming in here before the stream even starts to support the channel, which I appreciate so very much. All of you have been so supportive with your emails because you know all the hate that I've been receiving publicly, and I thank you for that because your kind emails make it worth it, as does being the voice for people who can't speak, the victims. And the victim in this case is police officer John O'Keefe. And in my opinion, he did not get a proper investigation into his death. And I have moderators in my chat who are former law enforcement. And trust me when I tell you I back the blue 100%. I have law enforcement in my family as well. And the fact that Officer John O'Keefe's death or murder scene was not treated with the utmost care and consideration, and every I should have been dotted and every T should have been crossed. And if you're new to this case, it will shock you when you start learning about how this investigation was mishandled from the very beginning. I'm going to say it was mishandled. It was mishandled. There was allegedly a nor'easter coming when Officer O'Keefe's body was discovered on the lawn of Boston police officer Brian Albert at around the 911 call was made at 6:04 a.m. 2 inches of snow had fallen. Please do not let people tell you that there were piles of snow everywhere. 2 inches of snow had fallen. Canton police were the first on the scene. They did their investigation. They found clear pieces of a broken drinking glass, 6 drops of blood which they collected in solo cups borrowed from a neighbor. They borrowed a leaf blower from a neighbor to blow off parts of the top layers of snow to try and unearth more evidence. And when they left, they did not secure this crime scene. They lost jurisdiction for conflicting reasons. Great choice of words, conflicting reasons. DA Marcy said that Canton PD lost jurisdiction because there was a conflict, because Boston police officer Brian Albert, who is the homeowner at 34 Fairview, the crime scene, his brother, Kevin Albert, was a Canton police officer. Therefore, it was a conflict for Canton PD to be investigating the scene. The other reason that we've heard is that Massachusetts State Police takes over jurisdiction in all fatalities. And this became a fatality at 7:50 a.m. when Officer John O'Keefe was pronounced dead. But you'll see from the deep dive that I know you're going to do, call me Alice because I fell into this rabbit hole big time. Trooper Proctor of the Massachusetts State Police, who does have close family ties to the homeowners, was called in on this case way before Officer O'Keefe was pronounced dead. But the CERT team, the Massachusetts State Police CERT team, did not come back to the scene and start investigating again until about, 11 hours later, when another 10 to 12 inches of snow had fallen and the crime scene was not secured. There was no tent put up to try and preserve the evidence, even though everyone knew the nor'easter was coming, and they said it was whiteout conditions at the time, but it wasn't done for Officer O'Keefe. Witnesses were interviewed in groups. None of the witness statements were recorded or signed or initialed even by any of the witnesses. And some of the witness statements that were taken by this close family friend weren't even typed up for weeks. And when asked to produce the notes from the investigation, the ADA, Adam Lally, who's assigned to this case, told the court there are no notes. So, if you haven't read about this case or learned about this case, I'll put the playlist down below and you can listen to it at your leisure because it can keep you busy for a very long time. Let us now see what's happening in the chat quickly before we move on to the documents. Thank you, Wine Cellar Infused, for becoming a member. That is really awesome of you. And Donna Nealon, thanks for your super chat. Just thanks for all your insight. Thank you. Thank you guys for the support. Kristen, thanks for becoming a new member. Yeah, let's unpack that. Thanks for becoming a new member. Suzanne, thanks for your super chat. MSP takes jurisdiction for murders in all Massachusetts cities, towns except Boston, Worcester, and Springfield. Yes, but were they conflicted? Is that why Trooper Proctor was called in before Officer O'Keefe was pronounced? We watched something the other day where they said that the employees of the Norfolk County District Attorney's Office responded to the scene. Well, they're Massachusetts State Police. They may be assigned to the Norfolk County District Attorney's Office, but there's a lot of word salad going on here, and you'll notice that as well. Lots of word salad. Thank you, Clara. Thank you so much for your super chat. This case needs an educated mind like yours desperately. Thank you for all your coverage. Thank you. Thank you for keeping me laughing because it's a very necessary job that someone needs to do, and I'm glad that you've taken it up. Rachel says, leaf blowers on an active crime scene, destroying possible footprints where someone carried a body outside. Yes, Rachel, yes. And despite the fact that they say this is a motor vehicle accident, there were no tire marks ever found or preserved. And if you didn't watch it, I had Joseph Scott Morgan on the other night, who is a death investigator and forensics expert. And I thought it was a great show. It was a Q&A. I had a lot of questions for him. We looked at some of the documents. I had him looking at photos, and he gave opinions. He was not as strong with his opinions as some people might have liked, but you can't fault an expert for not wanting to commit to an opinion without really seeing all of the documents. We don't have access to the whole 100-page autopsy report. We don't have any measurements on the wounds on John's arms. We don't know how deep they were, which is the difference, by the way, between abrasions and lacerations is depth. And I think he explained that, but there's been a lot of, I don't know, there was a clipping of like a 5-second portion of that video that the Karen Reed convictors seem to have glommed onto. But, that's their prerogative, I suppose. Today, I posted on my community page, Joseph Scott Morgan dropped an episode of his podcast, Body Bags, today on the John O'Keefe death. And so I suggest that you watch it. I listened to it. It's audio only. I listened to it today, and he has a lot of really interesting things to say about the clothing and how important it is in a case like this to properly preserve the clothing of the victim, because the clothing can tell you so much about what happened. And as you know, in this case, the clothing was pictured in a photograph on the hospital floor while Officer O'Keefe was in a hospital bed. And then the clothing was taken by Trooper Proctor and put, we don't know where, in the backseat of his car, in his trunk of his cruiser, for weeks before it was logged into evidence. So who knows how tainted that evidence was and that forensic evidence. But in the Body Bags podcast that I listened to today, he said that it's so important because if they are trying to claim that Officer O'Keefe was run over by this car, there would be evidence of that on his clothing. There would be grease. There would be oil. There would be remnants from the car. There would be debris from the car. And we haven't heard about any of that. We've heard that they sent his shirt to a forensic lab at UC Davis, and they tested his shirt for canine DNA, and that perhaps they did not find any canine DNA, but where was it? Joseph Scott Morgan said on my show the other night that clothing was wet. He was in the snow. They found him in the snow. The clothing was wet. If it's not properly preserved, the degradation of the forensic evidence is very quick, especially when you involve moisture. So I have questions. He also said on the podcast Body Bags, that dropped today about Officer O'Keefe specifically, he and his partner, and I'm sorry I don't know his name, were talking about the taillight and how the prosecution is alleging that the Karen's Lexus SUV coming into contact with Officer O'Keefe's body caused the taillight to crack or shatter. Now they're saying shatter. Originally it was a crack. Now it's a shatter. And his partner said those taillights are almost impossible to break. They're made of this material that is very, very difficult to break. The force that it would take to hit someone with a car to break a taillight is tremendous. So it was interesting. Listen to it later. I don't know when it was recorded, if it was recorded after he came on my show or before, but there was some more information in there for you guys to listen to. And I found it very interesting. If anybody has listened to it already, since I posted it earlier today, certainly comment in the chat and let people know what you thought about it. Sarah Harvey, thank you so much for your super sticker. And Truth and Transparency, thank you for your super sticker. Do you think John's phone was shut off and turned back on? The health data from 12:35 a.m. to 6 a.m. has not been talked about, so that's why I ask. We don't know. I mean, that's an interesting concept, because what we do know from the cell phone records that the defense has seen that were Jen McCabe's is that Jen McCabe made something like 26 phone calls during, I think, the time periods that you're talking about to John O'Keefe. That's curious to me. And so I don't know, but that's a great point. Anybody who wants to chime in on that? There's some speculation about why Mrs. McCabe called him so many times. His phone, as you know, was found underneath his body. When he was found, he was laying 12 feet from the road on his back, with his hands by his arms by his side, and his phone was underneath his body. So that's interesting. Crime Genius says they probably could not find his phone. And that's exactly the speculation that I'm talking about. Says Mindy as well. She couldn't find it, huh? Trying to find the phone. I don't know. Yeah, butt dials. More butt dials, says Just Jay. 26 phone calls, I'm sure. They were all butt dials, right? Yeah, there's a lot of my pleasure, truth, and transparency. My pleasure. And I see some of the work that you do, and it's really you do a lot. You're a very hardworking YouTuber, and some of the stuff we'll talk behind the scenes. Lisa says also Ms. McCabe's Apple Watch showed she was pacing all night long. But you see, nobody wants to hear that from, our side. Now all of a sudden everyone's on a side. It's a side. How about being on the side of what really happened to Officer John O'Keefe? Isn't that what we should be focused on instead of sides? It's insane to me. Yeah, and I want to talk about, too, some of the things that were subpoenaed, I think, in Aiden's case, which is insane to me. And if somebody, I want to pull that up later. Just remind me, because for those of you who don't know, Aiden Carney is also known as Turtle Boy. He's a local journalist from Massachusetts who started covering this case and what he calls a cover-up, and what many people believe is a cover-up and a frame job, very, very deeply. And he was arrested on charges of witness intimidation. I don't want to even get into a whole side thing, but now it's become sort of inextricably intertwined, because in the Aiden Carney case, which is, I believe, is it in district court or is it in superior court? They asked for, and I don't know if they obtained this, but their theory is that Aiden is conspiring with Karen Reed to intimidate witnesses. And in search of this, in this fishing expedition, looking for evidence of this, they subpoenaed Aiden Carney's records from a car that he bought from the dealership, wanting to know how he paid for it. And not only that, they somehow got, his bank statement. I don't know exactly what it was. Karen Reed's father's records for any cars that he has purchased since January 29th of 2022. And I think her brothers, Karen Reed's brothers, and then another friend of Karen Reed's, all of his phone records. And you've seen how hard it has been for the defense in the Karen Reed case to get third-party discovery, cell phone records, text messages, Google searches, etc. How is that? Yeah, Kevin, first of all, how is that not an invasion of privacy? But how is that? Thank you, Olivia. Karen's father, her brother, and one of her close friends. So clear this up for me, Olivia, or anyone who can answer this question. Are these things that they're just asking the judge to so order subpoenas for? Did Karen's father, her brother, and one of her close friends have the opportunity to come in and be heard on this as third parties when the prosecution wanted discovery on this? Or did he just let them have it? I'm so confused, because that should infuriate you. They received all the documents already. So did the court sign off on those subpoenas for third-party discovery without even hearing from the third parties, as Judge Cannoni has required be done in every single request by the defense to get third-party records? I am shocked. I'm shocked. How could that? They've done more investigation into that case than they did into Officer O'Keefe's murder. Wow. Yes, and this happened too, Chloe's mom, right? They accidentally subpoenaed the wrong phone number, and they got an innocent person's phone records. Wow. And Scully Wonka, I wonder who the judge is that signed the warrant for these items. Karen's family and John Silvestri, that's the friend of Karen, were not allowed to challenge the subpoena. Oh, well, that's interesting. Not only are your First Amendment rights at issue in Massachusetts, but so are your rights to privacy. And wow. Nobody knew it happened until it was already in discovery. Oh, and what else they said today during Aiden's court appearance, because I did see a bit of this. I caught some of it on, I think Glare had it on earlier today. I think his name's Tim Bradle, Aiden's attorney, said that, and you know this because we went over this in this case. The Commonwealth turned over, I think after jury selection started, the grand jury transcripts from Aiden's case to the defense in Karen Reed's case. That was part of their discovery exchange. And Aiden's attorney doesn't even have the grand jury transcripts from Aiden's case. How did Lally and Marcy's office get possession of those grand jury transcripts before the defendant, Aiden Carney's attorney, got possession of those grand jury transcripts in his discovery? What? Again, Twilight Zone, I made an emoji. Use it. If you're a member, you can use it. But this should infuriate you or outrage you. I also have one that says, I am outraged. It doesn't show up so well. I got to make it a little bit bigger. I got to make the pixels bigger. Olivia, I don't know the exact details, but they've already received and looked through the records, I believe. It's outrageous. Yep, that's right, Lisa. Elizabeth Proctor didn't have to give her records. And we know that there was a text message exchange between Julie Albert and Michael Proctor's sister on the day that Karen was hauled into court first on February 2nd or 1st or 2nd of 2022. There was a text exchange from Julie Albert to Michael Proctor's sister, Courtney, that said, tell your brother I want to get him a gift when all this is over as a thank you gift. Her brother is Michael Proctor, the Massachusetts state trooper who's in charge of, who's lead on this investigation, who's longtime family friends with the Alberts. And Proctor texted back to his sister, tell Julie to get my wife a gift instead. So yeah, Elizabeth Proctor didn't have to give her cell phone records, but they've got all these records in this other court proceeding from Karen Reed's dad and brother and friend. Are you kidding me? Yeah, because that's legit, right? And I don't know how much attention that is getting, but it outraged me. And I just couldn't believe it. When I saw it posted, I'm like, no, that can't be. That can't be. That could be just like maybe they're making a request and they're going to have a hearing just like they had in Karen Reed's case. And they're going to let everyone bring their attorneys in and explain why they shouldn't have to turn that stuff over. But no, just let them have it. Tomo, is all just so unbelievable. I don't know. Lauren says we are outraged. Karen says we just found out. I just can't. Wow. So yeah, if you don't know about this, welcome to the rabbit hole. It's real. And maybe opening statements will be next Monday, which again, why is there no court on Thursday, Friday? Because again, in my opinion, let's rack up the attorney's fees for Karen Reed, because as we know, part of her defense team comes in from LA for this. So, let's just keep him here longer. Does anybody know why there's no court on Thursday and Friday? I want to see. Patrice is outraged. Maybe they're all planning their escape. Rescue Diver 1, I went to the Griffiths last show before Jerry died. Oh my God, you did? That's crazy. I was not at that particular show, but I was definitely at shows during the summer of 95. And that was a very sad day. I remember exactly where I was on that day. And if you know, you know. And for all my Deadhead friends in the chat, do you know who Big Steve is? Big Steve, he's got a show on the Sirius XM Grateful Dead channel. And he started a YouTube channel And my friend Jeremy, who was on the show with me one day as my producer, he is helping Big Steve with his YouTube channel. And tomorrow at 4:20 Pacific is going to be their first live. I'm going to put up a community post about it. So Jason Smith, you might be interested in that. Big Steve. Jason Smith, I'm ashamed of my Commonwealth. Yeah. I mean, a lot of you feel that way. A lot of you feel that way. All right, my friends. Here's the Commonwealth's response to defending Karen Read's motion to enforce her constitutional right to face-to-face confrontation. And this is about 3 pages. So we're going to read it because you might be saying to yourself, what? For those of you who didn't see us go over the defense motion, the defense has looked at the courtroom and they said, holy what? 6 of the jurors can't even see the witness's face. They can only see the witness's head, behind the back of the witness's head, and the side of the witness's face. And therefore, this is a violation of her constitutional rights to confront her accusers, and that the witness should face not only the defendant, but also the jury so that they can assess credibility. But here's what the Commonwealth says to that. Now comes the Commonwealth in response to the defendant's motion raising a perceived constitutional challenge. A perceived constitutional challenge, as you can see. Their choice of words is very telling here, because they don't believe in your First Amendment rights either. So, it's a perceived constitutional challenge to courtroom management issues regarding the location of seated jurors in relation to witnesses who are called to testify. Specifically, the defendant claims that the view of jurors seated in seats 9, 10, 11, and 12 violates her constitutional right to confront witnesses. See Defendant's Exhibit A. Defendant's Exhibit A were photographs that were taken from the perspective of jurors sitting in certain seats, and they had Mr. Yannetti sitting in the witness box, and it showed the exact view that juror would have from his or her seat. Quote, the defendant's right of confrontation requires the physical presence of a witness testifying against him or her, the witness's testimony to be under oath, the defendant's opportunity to cross-examine the witness, and the jury's opportunity to observe the witness's demeanor. Citing 2 cases. The defendant challenges only the jury's opportunity to observe the witness's demeanor. Demeanor is defined as, quote, behavior towards others, outward manner, end quote, and includes more than facial expressions. And then they cite the dictionary. Merriam-Webster Dictionary. Definition of demeanor. That's their citation. Demeanor is any outward behavior. It's the way a witness stands or sits, the manner in which they speak, their body language, their tone of voice, and their verbal and physical responses to questions. Jurors seated in the 4 challenge seats can observe the behavior, demeanor, side profiles of a testifying witness's face, and are within 4 to 6 feet from the witness stand. The Norfolk Superior Court was built in 1827, and criminal trials have been conducted in the main session courtroom with substantially the same setup for over 100 years. The Norfolk Superior Main Session Courtroom is also the largest courtroom in Norfolk County. The Commonwealth's initial suggestion to satisfy the defendant's concern was to position the witness's seat or instruct the witness to position their body to face the jury box. While also remaining in view of the defendant. And then they cite a case that they say, quote, as long as a witness is physically present in the courtroom, the witness is not required to look at the defendant, end quote. They cite a case that says it's permissible for the witness to sit at a 45-degree angle from the defendant where the defendant could see the witness's profile and lips. That's a case from 1991. And then they cite another case from 1989 that says videotaped testimony permissible where defendant could see witness by bending slightly. I'm going to submit to you that if you are going to try a woman for murder, Those people need to be facing her when they testify. They don't need to look at her, but she needs to be able to see them and their face and their facial expression. And so does the jury. I've never seen a courtroom set up this way. And it's almost laughable to me that they're opposing this and saying, well, demeanor means this. So even if you're looking at the back of the witness's head, you can still hear their voice. You can still observe their body language. You can still hear their cadence of their voice, their tone of voice, the manner in which they speak, the way they sit, and their body language and their verbal and physical responses to questions. It's okay. You don't need to see their face. I bet somebody like Dr. G would disagree. I should have called him to see if he could come on. He's a body language expert. And if anybody, agrees with the Commonwealth that it's not important to see a witness's face, please, by all means, come for me in the chat. I would love to hear the other side of this argument. Just because it's always been that way for 100 years doesn't mean it's right or proper. Next paragraph. The Commonwealth's initial suggestion, I think we already said that. Oh, no. Maybe we did. That the witness is not required to look at the defendant. Yep. They don't have to look at the defendant, but the defendant should be able to see their face, in my opinion. The defendant's motion indicates that Ms. Reed has already proposed an alternative seating arrangement, which will allow both Ms. Reed and all members of the jury the ability to observe witnesses who testify at trial. The suggestion posed by the defense was to move jurors' chairs to the other end of the jury box. However, as explained by the court, the jury box contained 12 seats at the time of the suggestion, and whereas 16 jurors will be seated for this trial, that space would be occupied by the additional 4 seated jurors. Given the defendant's objection, the Commonwealth offers another alternative, that the trial be conducted in courtroom 25 of the Norfolk Superior Court. While a smaller courtroom, criminal trials are often conducted in courtroom 25, and as detailed in Attorney Yannetti's supplemental affidavit, he previously conducted a trial within this courtroom, and during the trial, he had ample opportunity to observe the positioning of the box vis-a-vis the witness stand, as well as positioning of the witness stand vis-a-vis the defendant. They're citing Attorney Yannetti's own affidavit. Attorney Yannetti observed that every member of the jury in that courtroom could clearly see the witness's face while testifying. I also observed that the witness was facing the defendant. He said, see paragraph 8 of supplemental affidavit of counsel in support of defendant Karen Reed's motion to enforce her constitutional right to face-to-face confrontation. Respectfully submitted, XOXO, Michael Morrissey by Adam Lally, and this is dated April 19th. So the solution is to move this to a smaller courtroom so less people can come in. Rise Above says, OMG, they just want to be contrary for the sake of being contrary. Seems that way. Seems that way. Thank you, Lindsay, for your super chat. Melanie, we all love and respect you. Forget about the haters. They hate you because they ain't you. Oh, there's one that's coming after me hard. And I just can't wait for this to be over. I just can't wait. You know what I'm talking about. You don't need to say it. But it's like, it's getting personal now. And it's so bizarre. So bizarre. I don't get it. Thank you, though. Thank you, Lindsay. And Melva, thank you for becoming a member. And some guy with cancer, I'm so sorry about your cancer. And thank you for your super chat. Constitution is just a suggestion of Massachusetts, it seems. Yep. It's optional. It is optional. Thank you, Melanie Parker, for your super chat. Mel, they also arrested pro-Karen Reed protesters for protesting. Today? Mel, they did that today? I'll come to the chat in a minute, but I'm on the super chat stream. But didn't they threaten people who were honking as they went by that they were going to start arresting those people or giving out tickets as well to the motorists who were honking on their way past? And Shell's Kitchen, thanks for your super chat. How can anyone not see the huge red flags in this case? It's outrageous. Well, like I say, Aunt Shell, Auntie Shell Some people see red flags and other people see a parade. Street Squirrel, thank you for becoming a member. And Amy L 2022, thank you so much for gifting memberships. And congratulations for those of you who were gifted memberships by Amy. That was very super generous. Southern Mom, thank you for your super chat. Thank you for your always excellent coverage. If they don't fix the courtroom layout, it will be interesting, comical when witnesses have to ID Karen. They can't. Southern Mom, they can't not fix it. This is so basic that I'm surprised that they're saying this is the first time it's ever been brought up in 100 years. I thought maybe they typically try civil cases in that courtroom because civil juries only have 6 members, and maybe that made sense to me. Maybe, but make it make sense to me in any other world than the Karen Read case. What? Suzanne says they did not arrest anyone. They dragged 9 people before a magistrate in January. Oh, that's the Canton 9. Okay, so I thought that comment meant they arrested some people today. They still do not have a decision on the charges. No, why should they? Why should they? For protesting across the street from a pizzeria in town, they're arrested. You're right. And this is a major, there's a major, who's intimidating witnesses now? Who's intimidating people who want to speak up? It's crazy. They're talking about banning pink, says Mark Blaine. Well, they're trying to cancel Ted Daniel for wearing a pink shirt the other day. For those of you who are not familiar, Ted Daniel is a reporter with, who's he with? Boston 25? People are actually calling the news station to try and get him fired because he wore a pink shirt to court the other day. What? What? Dave the Pious, hello. So nice to see you here as always. Thanks for your super chat. If you're not getting hate, you're doing it wrong. Keep up the good works, my lady. Thank you. Thank you. It does help to have my feelings validated by the kind emails that you send and the kind comments and the, I see what you're doing when people attack me and you're backing me up. And thank you. Thank you for that, because it is a rough, tough YouTube world. Stay safe out there, my friends. Stay safe. Street Squirrel, Canton 9, we were not arrested, waiting to see if we will be charged. Okay, so you were charged. Are you part of the Canton 9, Street Squirrel? So you were given tickets, but not arrested? I know there's a lot of side cases to this case that admittedly I have not paid as much attention to as you would like. NBC 10, that's where Ted Daniel is. Thank you. Thanks, Rob Page, for that. Into Files, shout out to Tom CPU. Great job today. Tom CPU does some live streams from outside the courthouse. I did not see it today, but I think Glare put some of his stream on. But there are other days that I do watch. Paul Revere, Eliza says, is turning over in his grave. Suzanne says, the Massachusetts State Police is going to homes of people who dare to speak out. Should I be expecting a knock at the door soon? Because I'm in New York, so I don't know if they have jurisdiction here, but I don't know. Is jurisdiction a thing in Massachusetts? Control Freaks says KAK. Boston Fox 25. Okay, so I'm getting conflicting information on where Ted Daniel. Fox 25? Okay, Fox 25. That's where Ted Daniel is. He wore a pink shirt, and people are trying to get him fired. Brianna says, make it make sense. I just don't understand Massachusetts. Save my rights, please. Peter Strata says, are y'all sure you still live in a constitutional republic? I'm just, yeah. It's crazy to me, but, apparently I'm a conspiracy theorist. So, I mean, I absolutely think there's a conspiracy here. but it's not a conspiracy. It's not really a conspiracy. When you're a hammer, everything looks like a nail. I mean, confirmation bias, right? All right, Scott McGinnis with the deets. Used to be Fox 25 Boston, now it's Boston 25. They dropped the Fox part. Okay. All right. I think that jury box situation needs 100% to be straightened out. I don't know why it never has been before. I don't know that moving it to a smaller courtroom is a good idea. It's going to limit the number of people that are going to be able to be in the gallery. From what Suzanne said, it's a very, very small courtroom. So that's going to limit the amount of people that are going to, and with friends and family on both sides, it could take up the most of that small courtroom. Thanks, KM, for your super chat. Thank you, Melanie, from Southern Cal. Oh, one of my favorite places in the whole world. I would move there in a second if I could. South Bay is my jam. I would love to move there. Manhattan Beach, Hermosa, Redondo, Palos Verdes. Second. Do you think Unetti and Lally have both been able to read Higgins' proffer? If so, how can Lally and the state be so dismissive of these facts by Higgins? You're wonderful. Thank you, Callie girl. Callie girl. I don't know if they've been able to read his proffer. They will be able to use it, I imagine, in cross-examination. That's going to be a day you don't want to miss. If you're going to go for one day of testimony, I think that ATF agent Higgins would be the day to go. They're going to leave it up to a jury. The Commonwealth is hell-bent on trying this case come hell or high water. But, the fact that this is now dragging on until not being able to start until Monday is curious to me. So, I think that's the day. That's the day of testimony you don't want to miss. There's so much testimony that you don't want to miss. Colleen says when you get called out when you get called a conspiracy theorist, it usually means people calling those people calling you that are afraid of the truth coming out. Yeah. Yeah. Like Socrates said. All right. Let's take a look at their opposition now to the whole DA coming in as a witness thing. This is document number 346, Commonwealth versus Karen Reed. This is the Commonwealth's motion for an offer of proof prior to defendant calling or summonsing the Norfolk County District Attorney and victim witness advocate as witnesses and request for an order that neither is subject to a sequestration order. Sequestration order means that they would not be allowed to sit in the courtroom until after their testimony, and they don't want that. Michael Marcy apparently wants to come and sit in the courtroom for the whole trial. And that seems to be the what I'm gathering from their opposition to this. This is 3 pages as well. This is not a fly on your screen. It's my cursor. It's the way I got to move it. Sorry. Don't smash your television. Send me the bill. Now comes the Commonwealth and moves that this court order that the defendant make a satisfactory offer of proof prior to calling and or summoning Norfolk County District Attorney Michael Morrissey and victim witness advocate Stephen Nelson as witnesses, and for a finding that the district attorney and the advocate, Mr. Nelson, are not subject to any order of sequestration. On April 15th, 2024, the defendant listed both the district attorney and the victim witness advocate as potential defense witnesses. When a defendant resorts to, quote, the extraordinary means of calling a prosecutor as a witness, he must make a satisfactory offer of proof as to the need for testimony from the prosecutor, citing 2 cases. The prosecutor should be called only where there is a showing that the prosecutor's testimony is relevant material and not cumulative. He says the case that stands for the proposition that defendant failed to show that the prosecutor had personal knowledge of relevant factors, hearing on officer credibility that could not be elicited by other means. The same principles hold true for the advocate. citing a case that stands for victim witness advocate is member of prosecution team and notes discoverable or protected by work product rule to the same extent as prosecutor notes. District Attorney Michael Morrissey is the elected official of the Norfolk District, a position he was first elected to in 2010. The district attorney is the elected advocate of the people and chief law enforcement officer from the Norfolk District. Citing a case that says, district attorney is the people's elected advocate for a broad spectrum of special interests, societal interests, from ensuring that criminals are punished for wrongdoing to allocating limited resources to maximize public protection. On April 18th of 2024, at sidebar during jury impanelment, defense counsel made an insufficient showing of why District Attorney Morrissey's testimony would be necessary to their defense. Defense counsel indicated they would call District Attorney Morrissey to testify about the, quote, conflict the Canton Police Department had with the investigation and the assignment of the detective unit of the Massachusetts State Police assigned to the Norfolk District Attorney's Office. It is not in dispute that pursuant to statute, the district attorney and its law enforcement officers have exclusive jurisdiction over all death investigations in Norfolk County. See General Law, Section 38. Further, other witnesses are expected to testify that the Canton Police Department disassociated themselves from the investigation due to a familial relationship between the homeowner and a Canton police detective. Right away, that should make you go, Wait, so I'm going to assume that Canton PD, who was first to arrive on the scene, fully knew that one of their detectives' brothers lived at 34 Fairview. I'm willing to bet that Canton PD know where every police officer in that town lives, whether they're with Canton PD or Boston PD. And that when they got this call, they knew that it was a conflict, but they went there anyway. Mr. Nelson, is an employee of the Norfolk District Attorney's Office and is the assigned victim witness advocate in this case and has been assigned to the case since January of 2022. Generally, it says Victims' Bill of Rights in Massachusetts generally requires the staff of the district attorneys to ensure that victims and witnesses are afforded such rights. The victim advocates serve an important and salutary function. They provide victims, witnesses, and family members needed assistance, information, and support, and generally help them to cope with the realities of the criminal justice system and the disruption of personal affairs attending a criminal prosecution during a time of personal trauma. During trial, it is especially important that the advocate engage in an essential function of, quote, acting as a liaison between victims and witnesses and the district attorney's office. Neither the district attorney nor the advocate were percipient witnesses to the charges before this court. Well, I'm going to beg to differ on that. You can let me know if you think that Michael Morrissey is a percipient witness after we look at that video. And I'm going to get you the dictionary definition of percipient because we did this on another stream. So if they're going to quote the dictionary, so are we. A percipient witness is a witness who has obtained knowledge of an event directly through their senses, generally through sight or hearing. They say neither the district attorney nor the advocate were percipient witnesses to the charges before this court. To the extent the defendant may want to impeach proposed Commonwealth witnesses as to statements, the defendant has not shown the absence of alternative sources of said purported information. Further, to the extent the defendant is seeking either the district attorney's or the advocate's opinions or observations regarding witnesses, mental impressions, research, or evaluation of the evidence for the Norfolk County case, such areas of injury, I have injuries on the brain. Such areas of inquiry reflect privileged work product. Okay. Okay. Here's the thing about privilege. I'm going to talk about attorney-client privilege, doctor-patient privilege. I have attorney-client privilege if I am speaking with my client, and it's just me and my client, and we're in the room together. Once you bring a third person into that conversation or into the room, that privilege is deemed waived. So if my client wanted their sister to sit in during our conversations, I would say, well, you have to understand that if your sister sits in during our conversation, the conversation is no longer privileged, and you have to get your client's permission for that. There has been some evidence in this case that we have heard about in open court where the district attorney's office and the advocate met with or had conference calls with several witnesses at a time. And my argument would be, maybe not. Maybe it's not privileged. Their work product is privileged. This is, it's a little overbroad, but we'll see. Because there was a discovery request for notes that were taken or statements that were drafted during such meetings when Lally's office met with these witnesses prior to their testimony in front of the federal grand jury. And first in open court, Lally said, I don't even know what they're talking about. I don't remember any meetings. And then he suddenly remembered, oh, but if I did have any meetings with these people, it was just about them being harassed. And then we did the math on that. And the math wasn't mathin'. So there are some questions. The Norfolk County District Attorney's Office should not have met with any of the percipient witnesses in this case prior to their testimony in front of the federal grand jury because the Norfolk County District Attorney's Office does not represent those witnesses. In fact, most of those witnesses had their own attorneys because they came in to argue against Rule 17 motions. So the math ain't mathin'. And it's my opinion, and I'm sticking to it. Back to the document. Work product rule exempts from discovery those portions of records, reports, correspondence, memoranda, or internal documents of the adverse party which are only the legal research, opinions, theories, or conclusions of the adverse party or its attorneys and legal staff. And that is why they're citing that. What about just notes? What about just notes of the conversations? That doesn't fall under legal research, opinions, theories, or conclusions of the adverse party. Just the notes of what the witnesses said to you during those conversations. Those are discoverable under their own argument here. But, you know, they didn't want to turn those over. Therefore, the Norfolk County District Attorney's Office respectfully requests that this court enter an order that prior to calling or summoning the district attorney and advocate, the defendant make a satisfactory offer of proof before this court, and that this court find that they are not subject to any order of sequestration, meaning they don't have to not come into court and sit there every day and stare down the jury and the witnesses and the defendant. XOXO, Michael Marcy by Adam Lally. Say yeah, my friends. Chat's moving crazy, so I know you have a lot to say about that. Melissa Smith, thank you so much for your super chat. I'm missing my brother today who passed in 2020. I'm so sorry. He lived in Wantagh, New York, which is Long Island, where Jones Beach Theater is, coincidentally. And Ripple was his funeral song. Huge Dead fan and lifelong Long Island resident. Oh, wow. Wow. So I told you, and this is just, I'm only bringing this up because you brought it up, Melissa. My sympathy goes to you. that so many people have been, theorizing that I'm personally invested in this case because of the money that I'm making from it and the money that the defense team is paying me for their PR and clicks and likes and things like that. And the truth of the matter is, and I told you this one day in February, is that when I was in college in Colorado, Sco Buffs, Boulder, Colorado, I met a boy. And the boy was from a small town in Massachusetts that nobody had ever heard of. He was a huge Patriots fan. And he told people he was from Foxborough because everyone knew where Foxborough was, but he was really from a town called Norfolk, Massachusetts. And I'd never heard of it. But he was from a town called Norfolk, Massachusetts. And he would tell me when we were in college about local police and how corrupt he thought they were. And this is going back many, 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 many years. And we got married and we had 2 amazing kids together. And our marriage didn't last. We were together for about 10 years, but we still were on great terms. And the day that I told this story back in February was the day of his funeral. So the reason that I'm personally invested in this case is because of my late ex-husband's ties to Norfolk, Massachusetts, which is in Norfolk County, Massachusetts. And the stories that he was telling me from the time that we were in college. So there's that. You might want to take a step back on me being paid by the defense as PR. Okay. I'm not saying that for sympathy of any kind, but at his funeral, Melissa, that was the point of that story. In addition to my personal connection to the town of Norfolk, Massachusetts, my 2 oldest children, who were also his children, they played Broke Down Palace at his funeral. And that is another Grateful Dead song. So the Tommy Bernhard podcast. Thank you so much for your super chat. I think the court schedule works around barely have CPAP calibration sessions. Oh, thank you. Because I needed that laugh. Thank you. Also, Ted Kennedy called. I was extremely proud. New England is just as corrupt as he left it. Tommy, if your podcast is as funny as that super chat, I'm send me the link. I'm coming to watch it. Oh my goodness. Kelly Reed, thank you so much for your super chat. Thank you. Little Irish girl became a YouTube member. Welcome, welcome. I think you're going to like it here. We may not be cupcakes, but we keep each other happy. So there's that. Lorena Jenkinson, thank you so much for your super chat. Suzanne coming in again. Suzanne says, with her super chat, the DA and the ADA represent the people of Norfolk County, not the McAlberts. The people deserve all information. Could not agree with you more. Scott McGinnis, thank you so much for your super chat. DA Marcy operates akin to a godfather in Massachusetts. The trial court and all its appointed judges are beholden to his party. They are all one. Anything my super chatters say is their opinions and their opinions only. For clarity. Lorena, thank you again for another super chat. Butt dial trial is coming up. It's a great thumbnail. Butt dial trial. Come get your popcorn. Mine is the freshest, made to order. Nick and Kelly Reed is day old. Find me in the Justice Group. All right, Lorena. Thank you for that. So while we are here, District Attorney Marcy doesn't think that he's a percipient witness in this case, but I beg to differ. And the reason that I beg to differ is because of a video that he put out in August of last year that you may have seen. It's only 5 minutes and 44 seconds of what I call a hostage video. And let me know if you agree, because I feel like somebody's off camera holding a weapon and forcing him to read from a script. But that's just my opinion and my opinion only. I think that he may have made himself a witness in this case by what he says in this video. And I want to know your thoughts on that after we watch it. So let's watch this 5-minute tidbit and let me know what you think. Because it sounds to me like he's got some personal knowledge about what went on the night that Officer John O'Keefe was murdered. Be good if I put it on the screen before I hit play. So let me just do that. Come on over. Well, that's not it. All right. If you haven't seen this before, is there anybody who has not seen this video before? If you have not seen this before, wave in the chat, because this is so delicious that it deserves a better intro, but I just can't seem to gather the words to properly introduce it. But Lauren says, Marcy absolutely did. The statements in that statement are now proven false, but he stated as fact. He should have to take the stand and explain. Well, let's put this into context too, because this was right after the Commonwealth asked for and did not get a gag order in this case. They wanted a gag order. Judge Cannone said no. And then something aired with Alan Jackson and David Yannetti, and I don't know if it was 2020 or Nightline or what it was. And it was a 9-minute segment. And we know that because that was their opposition. Like, they had 9 minutes on TV after the gag order was denied. And so DA Marcy had to go on and he had to do a video and he had to counteract that 9 minutes. But his is only 5 minutes. So whatevs. But you'll notice behind him, there are these law books that nobody ever uses anymore because now there's this, amazing tool called Westlaw, which is internet research. So you might notice also that these books are all out of order in the back. They're not even in proper chronological order. It's kind of funny. And you'll notice also that he put out this video, not as a press conference. He didn't have any media there asking questions. It was just sort of let out onto the internet and given to the media without any questioning of him. He just read from a piece of paper. So take a listen and then tell me if you think that he has made himself a witness.
This will be the first statement of its kind in my dozen years as Norfolk District Attorney. The harassment of witnesses in the murder prosecution of Karen Reed is absolutely baseless.
The first of its kind. The entire time he's been the district attorney since 2010. So there's a reason for that. There was a motion made also. You'll see my playlist. There's a stream that we did called Motion to Disqualify the Norfolk District Attorney. And that motion was denied by Judge Cannone, big surprise. But there were many reasons set forth in the motion to disqualify, one of them being this video that he made. Because this is unprecedented. District attorneys do not insert themselves into murder cases like this by making statements like this. Yes, he's a lawyer, Nancy. He's also elected. He's not appointed. So he's been in office since 2010. We went over his resume or his curriculum vitae one day, and he's a lifelong politician. I don't know if he tries cases. I don't think he tries cases in Massachusetts, but he's in charge of all the other ADAs. There's a reason why he's never made a statement like this, and it's because it's insane. But I'm going to try and stop and just let it play through until I absolutely have to stop it. But I put the closed captions on, so I'm going to restart it. But just tell me, because I know a lot of you, I'm not a body language expert. If you can tell by his body language what is going on there behind the scenes. Why is he, what's the motivation in even making this statement to the public? And how you could possibly, what happened to innocent until proven guilty with regard to a criminal defendant who's on trial, who's charged with murder in your county, that you are in charge of prosecuting? And as an attorney, some of you don't know that in addition to taking the bar exam, you have to take an ethics exam. And you are bound by the Code of Professional Responsibility. And one of the number one things that is drilled into your head when you become an attorney is to avoid even the appearance of impropriety, even the appearance of it. And this, I submit to you, my friends, is way more than the appearance of impropriety. But again, just my opinion. I'm sure there's lots of people that would disagree with me. So for those of you who haven't seen it, buckle up.
This will be the first statement of its kind in my dozen years as Norfolk District Attorney. The harassment of witnesses in the murder prosecution of Karen Reed is absolutely baseless. It should be an outrage to any decent person, and it needs to stop. Innuendo is not evidence. False narratives are not evidence. However, what evidence does show is that John O'Keefe never entered the home at 34 Fairview Road in Canton.
John, what the evidence does show, this is what your district attorney is telling the public on television. It's broadcast on every news channel and it's on YouTube. He is telling the people of Norfolk County, the people who will sit on the jury of this case, that the evidence shows that John O'Keefe never entered the home at 34 Fairview in Canton. Are you freaking kidding me? This was in August of 2023.
The night he died. Location data from his phone, recovered from the lawn beneath his body when he was transported to the hospital, shows that this phone did not enter that home. 11 people have given statements that they did not see John O'Keefe enter the home at 34 Fairview that night.
Well, now we're finding out there was 13 people in the house. So they only had 11 statements in August when he made this video, this hostage video. Or maybe they had two other statements who said he did come in the house. Now I wonder. Now this makes me wonder. But are you kidding me? You're going to opine on the veracity of the cell phone data, of the forensic evidence, which is clearly going to be disputed by experts in this case. Okay, I'm going to try and stop.
0 people have said that they saw him enter the home. 0, no one. Some have, without any evidence, pointed to 18-year-old Colin Albert, a nephew of the homeowner, and accused him of attacking John O'Keefe as he entered the home. But phone evidence shows O'Keefe never entered the home at all.
Phone evidence shows O'Keefe never entered the home at all. He's gonna double down on the forensics and tell the jury pool what the evidence shows before a trial. Are you kidding me? We are outraged. I have to talk a little bit more softly because I know that the audio on this isn't great. It's not my audio, it's the audio of this actual video. Speak softly and carry a big stick.
Testimony from witnesses tell us that 18-year-old Colin Albert had left his uncle's home before John O'Keefe and Karen Reed had arrived outside the residence. There was no fight inside that home.
There was no fight inside that home. Anything the defense telling you is complete BS. Why is he so... I'm sorry, I forgot to speak softly. Why is he so focused on making sure that everyone knows that Colin Albert was not inside that home when John O'Keefe did not go inside that home? Why is he so intent on that? Think about that to yourself.
O'Keefe did not enter the home. Colin Albert, the young man being vilified, was not present when Reed's vehicle and John O'Keefe arrived on the street. This is a false narrative.
Calling the defense's theory a false narrative. Tainting the jury pool much?
Colin Albert didn't commit murder. Jennifer McCabe, Matthew McCabe, and Brian Albert. These people were not part of a conspiracy and certainly did not commit murder or any crime that night. They have been forthcoming with authority, providing statements, and have not engaged in any cover-up. They are not suspects in any crime. They are merely witnesses in the case. To have them accused of murder is outrageous.
What are they witnesses to? If he never came in the house, they didn't see anything. So what are they witnesses to? All of them gave statements that at the Waterfall bar, Karen did not seem to be intoxicated at all. At all. To have them accused of murder is outrageous. Yeah, Jennifer. Jennifer says, if I can get my cursor back over this screen. I don't want to swipe myself out, so I have to be very sensitive. The judge had no issue with this video, which is also wild. I have thoughts about why this case was transferred from Stoughton to Norfolk Superior and why those charges were upgraded to murder. I have thoughts.
To have them harassed and intimidated based on false narratives and accusations is wrong. They are witnesses doing what our justice system asks of them. The autopsy of John O'Keefe was conducted by a forensic pathologist from the Office of the Chief Medical Examiner. The doctor found that the injuries that left John helpless in the cold were not a result of a fight.
Yeah. Because the medical examiner was told to put in the autopsy report that the injuries were not as a result of a fight. Because that's what medical examiners do. They opine about what didn't cause the injuries. Right? He also didn't fall off a cliff. The injuries were also not a result of drowning. The injuries were also not a result of a plane crash. Why didn't the ME put that stuff in there too? Oh, because we found out that Trooper Michael Proctor and maybe another trooper, maybe it was Yuri Buchanan, were in the room during the autopsy, maybe saying to the ME, what did you put in there that there's no indication that he was involved in a fight? Why? Why would you put that in there if John O'Keefe never went in the house and Colin Albert was never in the house before John O'Keefe didn't get there? Why would that need to be in the autopsy report? I mean, do you really need to be a legal analyst to figure this out, or just a person with any sort of common sense and critical thinking skills?
She further found that the line of abrasions on his arm was consistent with blunt trauma, not an animal attack.
Blunt trauma. Blunt trauma, which somebody opined in a video that Will so classically critiqued on his show last night. This person who's supposed to be an expert said blunt force trauma is when something sharp cuts you, like a piece of metal or a piece of glass cuts you. That's blunt force trauma. I don't think we need to go to the dictionary for blunt force trauma, do we? Let's let Morrissey dig his grave a little more, shall we?
Grand jury of everyday citizens. Abrasions on his arm was consistent with blunt trauma, not an animal attack. A grand jury of everyday citizens heard the documented evidence and testimony before making a decision. The subject of that murder indictment enjoys the constitutional presumption of innocence. Why should the witnesses who have committed no crime be afforded less by members of the community?
Wait, what?
They should not be harassed.
Wait, what? Oh, but Karen Reed is not afforded the presumption of innocence, right, District Attorney Morrissey? Because you're telling your entire county and anybody else who finds this on YouTube, so really an international audience, that Karen Reed is guilty. So she's not entitled to the presumption of innocence. But these poor witnesses who, I don't know, may or may not be lifelong friends of yours, they're entitled to the presumption of innocence. I got to take that back a second, because every time I watch this hostage video, I see more.
That left John helpless in the cold were not a result of a fight. She further found that the line of abrasions on his arm was consistent with blunt trauma, not an animal attack. A grand jury of everyday citizens heard the documented evidence and testimony before making a decision. The subject of that murder indictment enjoys the constitutional presumption of innocence. Why should the witnesses who have committed no crime be afforded less by members of the community? They should not be harassed.
Oh, so she was afforded that presumption before the grand jury indicted her, right? Right? But now that she's been indicted, you know, I'm going to tell you that nobody else did this except for her. Are you kidding me?
For telling the government what they heard or saw. I'm asking the Canton community and everyone who feels invested in this case to hear all the actual evidence at trial before assigning guilt to people who have done nothing wrong. And certainly before taking it upon yourself to harass citizens who evidence shows have done nothing in this matter but come forward and bear witness. We try people in the court and not on the internet for a reason.
But isn't that exactly what you're doing? Isn't that exactly what you're doing here? You're putting this video up on the internet instead of letting this case play out in court the way that you are sworn to do as a public servant representing the people of Norfolk County. We don't try people on the internet for a reason. Okay, so why are you doing that? Rules for thee, but not for me?
The internet has no rules of evidence. The internet has no punishment for perjury. And the internet does not know all the facts.
But you do.
Conspiracy theories are not.
But you know all the facts because you know that Colin Albert was not there. You knew that John O'Keefe never went in the house, so you know all the facts, huh? How do you know those facts? How did you become aware of those facts? Because you got on TV and you said that they're facts. So tell us how you know. What is the source of your knowledge, counselor? What is the source of your knowledge for those statements?
Evidence. The idea that multiple police department, EMTs, fire personnel, the medical examiner, and prosecuting agencies are joined in or taken in by a vast conspiracy should be seen for what it is, completely contrary to the evidence and a desperate attempt to reassign guilt.
Desperate attempt to reassign guilt, completely contrary to the evidence, because I am the district attorney and I have the case file. And according to me, this evidence shows you that Karen Read is guilty and that this desperate attempt to reassign guilt and this third-party culprit theory holds no water. And I'm telling you that, but I'm not going to take any questions about it. And he's reading off a piece of paper, and it seems like there may be a hostage situation happening here. Am I crazy?
Michael Proctor, the state police trooper, being accused of planting evidence outside 34 Fairview Road, was never at Fairview Road on the day of the incident. Proctor and his
BS. That is BS. And we know that it's BS. You know why? Because there's police reports that put him on the scene at 34 Fairview on the date of the incident. But your district attorney just said publicly for all the world to see that Michael Proctor was not at the scene on Fairview Road on the date of the incident. I'm going to rewind it because it's so delicious that you need to see it again. Because if you didn't see it, you just wouldn't believe
it. For what it is, completely contrary to the evidence and a desperate attempt to reassign guilt. Michael Proctor, the state police trooper, being accused of planting evidence outside 34 Fairview Road, was never at Fairview Road on the day of the incident. Proctor and his state police partner traveled together the entire day while other officers were processing 34 Fairview. Trooper Proctor was not there and did not plant evidence at 34 Fairview Road.
I lost count. How many times did he say that Michael Proctor was not there? James Lynch says Marcy signed the police reports that put Proctor there. You can't make this up, folks. You just can't make this up.
In addition to having no opportunity to plant the evidence, as has been suggested, Proctor would have no motive to do so. Trooper Proctor had no close personal relationship with any of the parties involved in the investigation and had no conflict.
Until until he testified in front of the federal grand jury, which is investigating the investigation of the Karen Reed case, and admitted, yeah, I lied about my relationship with the people involved, and I actually do have close personal ties to the people whose house I did not search, on which the front lawn of which Boston police officer John O'Keefe's body was found. So again, he's lying to you, Norfolk County, and he's made himself a witness in this case, in my opinion, and he should be forced to testify. Because isn't it true? Isn't it true, Counselor, that you signed off on this police report where it says that clearly Trooper Proctor was at the scene? Isn't it true? And yet you went on worldwide television? The fact that he was not disqualified from this case based on the motion papers that we looked at and blows my mind. But he made himself a witness. And for those of you who are just tuning in, this is not new. This video was released by District Attorney Marcy back in August of 2023. And this is a shining example of what district attorneys should not do. Who was it that was either on my show or on another show who said they showed this to their law students in class as an example of what a district attorney should never do?
And he had no reason to step out of this investigation. Every suggestion to the contrary is a lie. This should be seen for what it is and not used as a pretext to attack and harass others. What is happening to the witnesses, some with no actual involvement in the case, is wrong. It is contrary to the American values of fairness and the constitutional value of a fair trial. It needs to stop.
Didn't you just blow Karen Reed's shot at a fair trial in the first 5 minutes and 21 seconds of your speech, of your TED Talk, of your proclamation? That John O'Keefe, the evidence shows that John O'Keefe never went in the house. The evidence shows that none of these people that are being harassed had anything to do with this, that they are just doing their civic duty of being witnesses in this case, and that it needs to stop. It needs to stop. I mean, the fact that Karen Reed's civil rights are being trampled on all over the place without anybody giving a shit. And I never curse on this channel. I don't. I'm sorry. It makes me mad. If you have your kids in the room and you don't have your headphones on, I know if your 95-year-old mother is there, I'm sorry. Every time I watch this, it makes me more angry.
And the constitutional value of a fair trial. It needs to stop now. I am releasing this recorded statement rather than holding a news conference because my remarks need to be so narrowly tailored to the issue at hand while the prosecution is pending in Superior Court.
Anybody think that was a narrow tailoring of his words, and that's why he didn't take questions? Is that what you think? Ed, he hasn't read a single one of those books. I don't think he's read the rules of professional conduct either. Wow. Phoebe says, watch, they'll switch to a smaller courtroom and say no cameras allowed, not enough room. Yeah. It's almost like I want him to say, I am making this video as evidence of proof of life, and you need to deliver tomorrow $6 million in small bills to be delivered. Come alone, money in a black duffel bag, and leave it in the trash can outside the town square in the northwest mailbox or garbage can. Come alone.
But the message is the same. What is happening to these innocent people, these witnesses, is wrong, and it needs to stop.
stop. It needs to stop. It needs to stop. And I am outraged. And you should be too. Because the only one who's entitled to any semblance of fairness is the people who are not on trial for murder. I'm shocked. I'm shocked. I'm shocked. And I am outraged. All right. Why my camera's doing like some weird thing. Hold on a second. I gotta make it stop. It needs to make it stop. No, go over there and stop tracking me. I'm moving too much. It's tracking me. Stop. Okay, stop. 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 It's freaking out. It's freaking out on me. It's mad. It's mad too. It's mad. Everybody's mad. We're all mad. We're outraged. We're not just mad. We're outraged. Am I crazy? Let's go back to the chat and check in with you guys because it's going to be puck drop soon here for the Rangers at Madison Square Garden. And I'm here for it. I'm here with you. But hockey is my thing. Thank you, Carrie, for the Cash App. And Carrie says, will you cover the trial in its entirety? Oh, I am not going anywhere, my dear. I'm going to be right here with you. Brandy Churchwell and I need to discuss how we're going to do this as far as splitting it up or dual streaming, because it's a lot. A lot. It's a lot. Brandy was not feeling well yesterday, so I'm not going to harass her right now. But we're going to talk about it and we're going to do it. We're going to do it. Thank you so much, Stacy, for your Venmo and for your no question there, but you sent me an email and I will take a look at that. And for Nancy, thank you so much for the Venmo and says, thank you for all that you do. And for Robert Scanlon, thank you so much for the Venmo coffee. And while we gather our thoughts, I think now is a really great time to just listen to a quick word from our sponsor, because I have a sponsor on this channel and that makes it easier for me, because when YouTube strikes me and all, I'm not as affected by it. But in any event, if you have not heard about the huge data breach of AT&T Wireless, you may be affected. And Aura was my sponsor before that big data breach. Remember, if you have AT&T Wireless, you might remember like last month when everyone had no cell service for like a day or 2 days. And they said, don't worry, we're just doing a software update. No big whoop. Here's $5 credit on your bill because for your inconvenience. Well, it turns out they had a massive data breach, and 74 million customers of AT&T Wireless had their social security numbers leaked to the dark web. Not just the social security numbers, but also dates of birth, personal information, all kinds of things. So it is not just current customers either. It's also something like 64 million customers before 2019. So if you have been affected, listen to the word from our sponsor. Aura may be for you, and you can sign up for a free trial with the link below. So take a listen. Did you know that the odds of falling victim to online crime are 1 in 4? Online crime is soaring. It's time to get smart about online safety. That's why I've been using Aura, the sponsor of today's video. Aura provides everything you need to protect your privacy, identity, finances, and your family in one easy-to-use app. Do you even realize how much of your personal information is already out there, being sold by data brokers to scammers, spammers, and anyone else who may want to target you? Well, if you Google yourself, you may find something like this. And it may shock you to know that your full name, home address, email address, health records, and even relatives, it's all out there. That's one of the reasons you need Aura. Aura shows you which data brokers are selling your information and automatically submits opt-out requests on your behalf. Not only does cleaning up this information reduce the amount of spam that you get, but it will protect you from hackers who could use the information to help them access your social media accounts, bank accounts, and other sensitive information. Aura also helps protect me and my family from online threats by providing antivirus and malware protection, a secure VPN with military-grade encryption, credit monitoring, spam call protection, parental controls, password management, identity theft insurance, and more, without having to download several different apps. It's really easy to set up. And best of all, I get everything at one affordable price. With the family plan, Aura will help you protect your kids by blocking harmful content, managing how much time they can spend online, and providing you with peace of mind while they game with cyberbullying and online predator threat alerts. I value my privacy and my online safety, and I value yours too. So go to aura.com/Melanie Little to start your 2-week free trial, because you can't put a price on peace of mind. I've also put the link in the video description below. You can thank me later. You can thank me later. Oh, that reminds me of another story. And starting at $12 a month, it really is a great deal because you get the VPN and you get the malware protection. I remember one time years ago when I only had a desktop in my home office that I think Russian hackers got into my computer somehow, and they took all my data and held it hostage, and they wanted me to pay them like Bitcoin of like $5,000 to get my information back. Like, it was insane. My IT guy's like, well, you could pay them, but it's not going to guarantee they're going to give you back your information. This will protect you against that kind of stuff too. So I used it. I think it's great. And it would help the channel if you would sign up for a free 14-day trial. The link is right below the video. Going back to the super chats and questions. Terry Robbins, thank you for your super chat. Cubert, I was so good at that video game. I was really, really good at Cubert, and that brings back a lot of memories. Thanks for your super chat. Chief Rafferty lives in Norfolk, as does Tully, Jen McCabe's parents. Okay, well, that's interesting. That reminded me of something. Oh, yes, as far as transparency goes in Canton, Chief, for those of you who don't know, Chief Rafferty, Helena Rafferty, who's the chief of police currently of Canton, was involved in a pedestrian knockdown motor vehicle accident all the way back in February with her police vehicle. She struck an elderly man, I believe, who was wearing a reflective vest in a crosswalk with her police-issued vehicle, and injured him so badly at a low speed that he required, I think, something like 9 surgeries, but never told the people of Canton about it until Aiden Carney reported on it, and then she had to come clean. So that's what's going on in Canton, folks. Something's in the water there. Tommy Bernhard, thank you for your super chat. That side is the nerve to make fun of Karen's face. I mean, look at the Rocky Dennis stunt double up here. What an embarrassment with his 900 LDL. Yeah, somebody on I don't know, a cesspool took some side-by-side photos of me the other day, like a headshot that I had and a picture, a screen grab of me from the from this stream the other night, and they were wondering whether, or they were arguing with each other or agreeing with each other that I probably had a nose job of some kind, which I have never had a nose job. But this is what these people do. This is what these people do under fake names. It's disgusting. It's disgusting. Mandolin Win, thanks for your super chat. Only Quentin Tarantino could make this up. Thanks for everything. So appreciate it. So appreciate you. Don't ever stop. I'll never stop. It just infuriates me more. It just fuels the fire. Trust me, it fuels the fire. Morrissey's statement opens up the third-party culprit. Yes, it certainly does, doesn't it? Because why did he feel the need to come out and so vehemently deny it? Why did he feel the need to so vehemently deny it? It strains credulity. My friends, it strains credulity. I have merch that says that, in addition to the merch that says, come for me in the comments, which I would appreciate more so than, the anonymous ridiculousness that people do. But thank you, Madam Ross, for that super chat. Jay Gann became a member. Welcome. Tommy, again, is being a member for a month. Tommy, coming in. Dave Matthews Band in the Hall of Fame. I know, finally. It's finally happening for him. How many years have we been listening to Dave since, we were in college and he used to play small bars in Charlottesville. I'm so happy for the Dave Matthews Band. Yes, that's amazing. I know you're a fan as well. Solomon Landscaping, thank you so much for your super chat. On top, thank you for your super sticker. On top, thank you for another super sticker. You guys are awesome. Let's go back to the chat and see if we have any pressing questions. What did I miss just getting here? Oh, Kathleen, you have no idea. I have no idea. They're going to try and get in one more juror tomorrow, and then they're going to hear a whole bunch of excuses from jurors who knows, if they got home and they realized, I see the vitriol that's going on out there in the social media world about this case. And you know what? I don't need that aggravation in my life. I don't need it. Like, I don't think I want to be a part of this. I don't want to be a part of this. Who could blame them, really? Rangers, Rangers, Rangers. Let's go. Let's go, Rangers. The Garden is rocking. I mean, the Garden is suspended on cables, the Madison Square Garden, for those of you who don't know. And like, when the Garden rocks, the Garden really rocks. Like, it really rocks. And it vibrates. Like, the energy there is unlike any other venue for concerts. Saw the Grateful Dead there many, many times. And for Rangers games. And it's Madison Square Garden. That's it. Pat Sanford, this trial is a good test and who's capable of critical thinking. Yes, it is. They are, aren't they? Irish Girl, thank you for, she says, thank you for making this legal proceeding easier to understand. Thank you guys for watching. I mean, I sometimes think I feel like I'm in the Twilight Zone, and it's, the struggle is real. The struggle is real. But remember what Socrates said. Socrates said, when the debate is lost, slander becomes the tool of the losers. That's where we are. That's where we are. Mike Nichols, this channel's amazing. Free Karen Reed. Who is Karen Reed anyway? Who is she? Why would anybody want to frame her? I submit to you, my friends, Karen Reed is you. Karen Reed is me. Karen Reed is your sister. Karen Reed is my sister. Karen Reed is your mother, your daughter, your friend. And if Karen Reed did not have the financial backing to be able to afford the very expensive defense in this case, she'd be sitting in a jail cell still over 2 years later. So if you don't think that this is scary, I don't know what to tell you. We are all Karen Reed. That's right. We are all Karen Reed. And I don't talk about a lot of cases. But when I pick up a case, it's because I'm passionate about it, and it's because there's something about that case that makes me want to do a deep dive into it. And you know that I don't cover 100 cases at a time. I'm not going to come on here 3 times a day with 3 different videos about 3 different cases. I don't have the bandwidth for it. I don't. I'm covering right now the Oklahoma Panhandle case of Jillian and Veronica and those 4 monsters who did away with them in that custody battle. That was the whole impetus for the whole thing. I cover the Long Island serial killer case because it's where I live, and I've been here since those legs started washing up on Fire Island in '96 when my little kids were going to those beaches, and because of all the police corruption that happened here on Long Island. And that's the reason the Long Island serial killer wasn't caught in 2010 when they had a description of this 6'5" ogre who drove a green Chevy Avalanche, because the chief of police of Suffolk County was covering up things. And the district attorney in Suffolk County was covering up things. And you can Google that. James Burke was the chief of police in Suffolk County. He went to jail, prison. And Tommy Spota, who was his bestie from childhood, who helped cover it up, not the Long Island serial killer, but another case. Tommy Spota's still sitting in Club Fed, as we call it here, federal prison. So there's that. So when people say, oh, that could never happen, corruption could never happen. Oh, it does. It will. It has, and it will again. And Angel Fire says, wasn't he the one who told them to destroy the phone? We don't know exactly who told them, but that's the theory. Somebody in the district attorney's office told them that they could, and Brian Higgins went to the military base all around Cape Cod and smashed his phone, broke the SIM card. And we know, you know how we know? Because in the federal investigation, we found out that he took a proffer deal. And for those of you who don't know what a proffer deal is, it's sort of like, I'll roll over, I'll tell you everything I know, and in exchange, you either give me immunity or leniency. And that's real. That's very real. Brian Higgins, an ATF agent who is one of the 13 people inside 34 Fairview the night that Officer John O'Keefe was murdered. took a federal proffer. So, Stephanie says, make me laugh when people think cover-ups and corruptions is impossible. Imagine being so dumb. I imagine a lot of things, but I've been called every name in the book. Microdots has amazing work. If you guys have not seen the videos and the reconstructions that Microdots has done on this case, go to their channel and check it out. Check it out. If they say Karen did it, you know they're dirty. Rescue Diver says blunt force trauma is caused when something flat, like a flat object. Yeah, or a baseball bat could be blunt force trauma. Yeah. The other type is penetrating trauma, which is caused by a sharp object, which penetrates the body. Yeah. So, Kelly Reed, thank you for coming in here. Says free Karen Reed. I think you were discussing in the chat that you're Karen's cousin. And listen, our thoughts and our prayers are with you and your family, because I cannot even imagine what you're going through. I can't even imagine it. Like, it devastates me. Like, if this was my cousin, I can't. And the fact that this is now like going to be put over until next Monday, we all want this to be over. All of us want this over. We want it over. We want the truth. We want this over. And we see you and we hear you and we are here for you. Like, this is insane what is going on. Insane. And God bless your whole family, and God bless the family of Officer John O'Keefe, because nobody should be going through this right now. This is a Shonda. This is a Mishigas, which reminds me to say happy Passover to all my friends who celebrate. Peter Pranzo, retired law enforcement, homicide detective, sergeant, boss man, who's one of my amazing moderators, says Spoda and Burke love buds. Yeah, I think, you might be right on that. They're looking into Burke now. You see, they want all Burke's records on the Human case. So who knows what they're going to find. I mean, if that stuff wasn't shredded by now. But yeah, thank you, Patronus Glow, for being here, and all my moderators for making this a safe place for people to voice their outrage. Really, their outrage. Solomon Landscaping, we all might be carrying the way things are going in this country. Yeah, because the more they take from you, the more they will continue to take from you. Kristen says jealous. Thanks, my amazing moderators. Let's go Rangers. If you guys would be so kind, there's over 2,000 of you here. If you would hit that like button, that would be so amazing, because it really helps the algorithm and it helps people learn more about this case, because the narrative out there is not necessarily even correct on basic things, like the fact that Karen and John were not married. So if you want this stream out there, feel free to share it. Feel free to hit the like button, hit the subscribe button. It helps the channel. Hit the bell. Aura is below. You can get your free 14-day trial. Olivia says, Melanie, just imagine all of the exculpatory evidence DA Morrissey's office has withheld from other defendants they've previously prosecuted who didn't have the benefit of the federal investigation. And yeah, that is a scary thing. It's a scary, scary world. Stay safe out there, my friends. Stay safe out there. And remember, because it is so not hard. Really, it is so not hard. Just be cool, be kind, be classy, my friends. It is so not hard. Really, I promise you. It'll make you a better person. Good night, everybody. Let's go Rangers.